All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order and be seated.
Thank you. Good morning. We have two cases on the calendar this morning, and we'll take them in the order in which they appear. The first case is Gibbs versus United States. Counsel.
May it please the court. Fleming Terrell on behalf of appellant ONZAY Gibbs. I'd like to reserve 3 minutes of my time for rebuttal. The warrant here authorized police to rummage through Mr. Gibbs' cell phone, a repository of far more private information than would be found in the most exhaustive search of a home, looking not for particular communications or location data, but for any and all data that might inculpate Mr. Gibbs, exculpate him, or point to other suspects in a robbery investigation. And it did that on the basis of nothing more than a cut and paste of the arrest warrant, plus the fact that Mr. Gibbs had a cell phone with him at the time of his arrest. I'd like to just briefly preview the 3 points I want to make today to show why, just as in Burns, this warrant was so obviously overbroad and lacking in particularity that suppression was required. First, the affidavit made no effort whatsoever to identify probable cause to believe that any piece of data, much less every piece of data on the phone, had the nexus to the robbery that the Fourth Amendment requires to authorize a valid search. So what police were asking for and what the warrant granted them was a constitutionally intolerable fishing expedition. Second, to the extent, as the government argues, that there was some minimal showing of probable cause for communications among the multiple individuals who were involved in this robbery, or for location data at the time of the robbery, that slender showing of probable cause for a few items of data on the phone does nothing to distinguish this case from Burns on overbreadth, on particularity, or on the good faith exception. And that brings me to my third and final point, which is that the only distinguishing fact the government can point to here vis-a-vis Burns is that Mr. Gibbs was a suspect, whereas Mr. Burns was nominally just a witness, although as we've laid out in our reply brief, he was, according to the affidavit, actually in it pretty deep in that homicide. But that mere suspect status is not enough to bring this case within Abney's precedent for applying the good faith exception, where there's at least an arguable basis in the affidavit to believe there's probable cause for a broad range of evidence on the cell phone. So turning first to probable cause. Here, unlike in Burns, there was no assertion that the cell phone was used or even possessed during the offense. There was also no assertion, as there was in Burns, that the cell phone had the capacity to record GPS information and that it would contain that kind of location information. Also, there was no articulation.
If there had been.
I'm sorry?
If there had been, if there had been something credible in the affidavit to the effect that the cell phone records locational information,
yes,
of the person who is carrying it, would that justify a search warrant, at least for the locational data on the phone at the time of the offense? That's
right. That's what Burns held. And what Burns also held is that that kind of warrant would have to specify particularly that it was an authorization to search only for that location data.
So it's not, this is not something you think there is general knowledge that can be taken into consideration, that cell phones do that they all have this capability. And because there is this sort of notion that everybody is carrying around with them a cell phone record of their whereabouts,
right,
which would justify searching every phone of every suspect virtually,
right,
in every crime.
I think that's why,
for that limited information.
Right. And I think that's why Burns tells us that you have to be particularly vigilant about probable cause and particularity in the case of cell phone searches because they do contain so much information. And as the Supreme Court said in Riley, you can come up with a reason why there will be all kinds of evidence of the crime, including the GPS data. But I think it strays into the realm of impermissible conjecture to just assume without the government even asserting it in the warrant application, as they did in Burns and also as they did in Abney. Now, I don't know that whether the warrant in Abney had the attachment that Burns did explaining the capacities of the phone, but at a minimum, the detective attested that the phone, in his training experience, the phones of people who commit crimes in the District of Columbia contain location information. Here, the detective didn't even make such an assertion. He just copied and pasted the arrest warrant, said the person we've arrested has a cell phone, and asked, please let us look at every single thing on that cell phone to see if there's anything relevant to this crime. And that's exactly what Riley forbids. It requires a meaningful constraint on the authority's ability to rummage at will through this repository of even more private and personal information than the search of a home.
Do you think this is a question that might change over time? The government offers that or argues that there's a common sense conclusion that Gibbs had his phone on him. And I understand there's the issue of what phone, weeks later, all of that. But if you didn't have those problems, do you think it's something that over time, as phones become more ubiquitous, that argument might carry more weight?
I don't think so, because as this court said in Burns, vigilance is required to make sure that the vast private information that's contained on a cell phone is protected. And as the Supreme Court emphasized in Riley and this court in Burns, Carpenter says that the courts have to keep up with changing technology and adjust their Fourth Amendment application to that technology to make sure that just because people are now wearing tracking devices all the time, that doesn't mean that every arrest is automatically a warrant to search through those devices.
Is it true, by the way, that in this particular case, the search of the cell phone did not retrieve any locational information?
I believe that's correct.
And is it also true that the search of the cell phone did not retrieve any communications of value leading up to the crime, the commission of the crime in this case?
That's correct.
The only valuable evidence was the subsequent communications that Mr. Gibbs had that were interpreted as relating to the past offense.
That's correct.
And his anxiety and so forth.
That's correct. Yes. And there was certainly no, the government has said in their brief that perhaps you could infer because the people involved in this robbery were not physically together in the moments before it happened, maybe they were communicating by cell phone. There's, first of all, that inference is at odds with the affidavit, which describes the accounts of the complainant and the witness, who said nothing about any cell phone being seen, much less used in those moments. But there's no such sort of logical argument for why there would have been communications after the fact of the robbery to justify even a good faith belief in probable cause for those kind of communications.
Suppose the detective had written the following affidavit. Given the way this offense went down as reported by witnesses, it's plausible to think that they had some that the perpetrators had some communications by cell phone. They weren't writing letters to each other, and the thing was, done on such a spur of the moment basis that you could really sort of rule out plotting in advance. And what's more, this hypothetical detective would have said, given the way cell phones work, there's reason to believe it would show the location of Mr. Gibbs at the time of the offense, and that would be very relevant. And what's more, we police officers know, and prosecutors know from experience, that defendants often communicate with their co-perpetrators and others by cell phone after the offense. So there's reason to think there might be other communications on the cell phone. And what's more, this offense was committed with a weapon, gun, and a knife. Well, was there a gun? No,
don't think
maybe there was just a knife. But take out someone. And you know, we see this all the time where there are photographs and bragging on face, you know, whatever. So we have all sorts of good reasons based on our experience to look through this phone. Now, suppose the detective had actually made those sorts of arguments. Don't just say this would be a different case, which I got, but do you think that that would be that sort of explanation? And then the detective would say, and so we want to search for photographs and, you know, of weapons and other things, and locational information for this defendant with some specificity. Would that have been enough to save this warrant in your view?
I think you just made the first point that I was going to make, which is that the warrant would first have to be constrained to those
This warrant
categories
said
of
nothing,
data.
but I mean, this affidavit said nothing and the warrant said nothing.
That's right. I think that would, I don't think that would be sufficient. This court has not endorsed the notion that has been applied in some of the specific drug trafficking cases, for example, that courts, the warrant judge can rely just on an assertion of a police officer's training and experience to conclude that there will be evidence and that it will be located in a particular place. And those, there is a split among courts. I think we lay that out in footnote 6 of our reply about whether that is something that meets the requirements of probable cause. And it's subject to the, I think, very valid criticism that it is basically endorsing those kind of statements, particularly for cell phones, which contain, again, such vast private information, and for which we all have the intuition that there's, because they contain so much information, you can draw all kinds of connections to what people generally have on those phones. Relying on those kind of trusted training and experience assertions from police alone without some particularized connection to the phone in this case is an invitation for police to make sort of boilerplate invocations of their training and experience and turn every arrest warrant into a warrant to search the phone for all kinds of personal and private data without any real reason.
A lot of the case law talks about limiting it to a specific crime.
Right.
Does that fix it if they're saying we are only searching for evidence of this crime and we now need to ignore evidence of other crimes?
I'm glad you asked that, because I wanted to be sure to say that no, Burns specifically rejected that rule, which the government proposed in Burns, that it is sufficient for a cell phone search warrant to be limited to evidence of a particular crime. This court in Burns said, we're not persuaded by that rule to begin with. Second, the government's cases that it cites in support of that rule are distinguishable. Some of them are distinguishable on the fact that they would have had a great deal more evidence. There was probable cause to believe there was a great deal more that evidence of the crime would pervade the phone, right? And third, those cases don't even stand for the rule that the government proposed, because what they say is that you can only get away with a warrant that just limits the search to evidence of a particular crime if it is not reasonably possible to describe that evidence with more particularity. Here, of course, it certainly would have been reasonable.
So understanding that for going forward, if we're looking back now and we're looking at this good faith exception,
yes,
what guidance was there available for the government back then? As I looked at the cases, it seemed pretty nebulous, and there were some jurisdictions like Massachusetts that seemed to be pretty strict. And like on the I think it was the Com case, and then there was Nebraska, which said it wasn't even necessary to say my experience in training, the fact that there were multiple perpetrators. They held this both in 2014 and 2019, their Supreme Court. It was enough to say there were multiple perpetrators there to show that a cell phone would have probably been used to communicate and establish enough of a percentage of probable cause.
right. I think so. First, Burns holds that there was enough case law in the sort of bedrock foundational Fourth Amendment cases holding that a search warrant has to limit the authorization to search to the specific areas and the specific things for which there's probable cause. It has to be carefully tailored to its justification. That's from Maryland versus Garrison. That police, even in Burns, before the Burns decision issued, right? Police evaluating that warrant in 2015 could not in good faith rely on the limitation to evidence of the particular homicide as enough to satisfy the particularity requirement of the Fourth Amendment. So there cannot be, consistent with Burns, a finding of good faith reliance upon just that rule that the government has proposed in Burns and was rejected and proposes here.
Can you, now that you've mentioned good faith, I didn't want to, I've forgotten now what your second point was, but if I could ask you, there's a lot of comparison of the small and larger factors that are different between ABNY and this case, but
right.
What principles can you pull out of the two of them? How do you reconcile them, and what principles would you pull out sort of going forward to apply to, I guess, this case now that the ABNY's come down?
Right. So that gives me an opportunity to make my second point very quickly, which is just that the warrant authorization here, like in ABNY, like in Burns, they were all equally broad. So there's some mention in ABNY, and there's a mention in, I think, the government's briefing that the warrant in Burns authorized a search for internet records without an explicit restriction to evidence of the records related to the homicide. And as we pointed out in our reply brief, that's not what the court in Burns interpreted the affidavit to mean. So moving on from that second point. So now we're in the world of, there is clearly, this warrant is clearly overbroad and lacking in particularity under Burns and under the Fourth Amendment case law that Burns applied, right? Now we get to ABNY, and how do we reconcile the two? ABNY emphasized the narrowness of its ruling repeatedly. And I think the takeaway lesson from ABNY is actually that the court recognized there that suspect status, merely suspect status, or probable cause to arrest is not by itself enough to support a good faith reliance on a warrant to search for all evidence of a particular crime. ABNY went on and said, there's more here, and highlighted the two important facts in the affidavit that that could have given police a good faith belief that there was probable cause, not just for some narrow range of evidence, but for a great deal of evidence about the offense. Emails, texts, photographs, recordings, web searches, all of those were things that the affidavit contained an attestation based on the detective's training and experience would be on the cell phone of anyone who committed a crime in the District of Columbia. Now, for the reasons I've already said and that we elaborate in our reply brief, that I don't think that's enough for probable cause. I don't think the court should hold that that's enough for probable cause, and it didn't hold that that's enough for probable cause in ABNY, but it did say that could have been enough at the time, pre-Burns, to conclude that for police to believe we've got probable cause to look for a whole bunch of different stuff on this phone. That combined with the other additional important fact that ABNY highlighted, which was that there was evidence that the phone had been used in the crime as an instrumentality of the crime. So there's some meat, there's a little meat on the bones of probable cause. And it pointed in that case to not just GPS data from the time of the offense, but to a great deal of information on the phone. And the ABNY court then, in moving on to discuss good faith about the particularity of the warrant, said, because there was that broader showing, that showing of probable cause for a broader range of evidence, that is why this case is different from Burns. And the reason is because it narrowed the gap between the authorization to search for all evidence related to the offense and the showing of probable cause for evidence relating to the offense. So I think what ABNY, the way to reconcile the two is to say that ABNY recognized what Burns recognized, what Riley implicitly indicated, which is that suspect status, an arrestee plus a cell phone does not equal even good faith basis to believe that police can go rummage through that cell phone for any and all
Getting
evidence.
that from Abney just because there was more, or did the court actually indicate something like, even if, you know, there were just the suspect status of?
Your Honor, respectfully, I think the court indicated that. And maybe it's helpful to just to sort of walk through the Abney opinion. At page 836, 863 and 64, this court started off saying it's undisputed that there's probable cause to believe that it was Mr. Proctor, the co-defendant, whose cell phone it was, that he participated in the robbery. But the court doesn't stop there, right? If that were enough for a good faith belief that you could search for all evidence of the crime on the phone, the court didn't need to go on and say anything else, but it did. It said, in our view, officers could reasonably have believed the affidavit also established probable cause that the phone contained evidence of the robbery. So there the court's recognizing that these are two separate inquiries, which is consistent with all the preceding Fourth Amendment case law, right? It goes on to lay out the factual circumstances that are described in the affidavit, which is not just that this was a suspect and a multi-perpetrator robbery, but also that there was this broad assertion based on the officer's training and experience that the phone would include information about the offender's location on around the date of the crime, internet searches related to the crime, images relating to or depicting the crime, communications with associates relating to the crime, and statements to others about the crime. So the court is focused on that much broader assertion. And then finally, that there was evidence that the phone was used as an instrumentality of the crime. Abney went on and cited a number of cases to sort of make the point that on those circumstances at the time, courts might have been divided over whether that was enough for probable cause. And all of those cases contained, as Abney points out, a claim based on the affiant's training and experience that there would be a
And so,
lot of
counsel,
evidence on the
I
phone.
already asked you a little bit on this before, but Abney was a warrant from 2018. And here it's a warrant from 2016. And a number of those cases cited in Abney are from 2017 and 2018 afterwards. And there didn't seem to even be in some of the cases, or at least part of the cases available before then, that experience and training requirement. How do you, in nailing down deeper on the time period, taking away that extra 2-year period, how do you nail down what the requirement should have been here?
I think that makes it even more implausible that police could have believed, looking at this warrant, that there was probable cause for anything, much less a broad range of evidence. If there weren't even cases at the time, and I haven't sort of researched the full range of cell phone cases involving the training and experience assertion, there may be ones from before 2016, 2015. But to the extent there weren't any, then that's even more reason to conclude that the police just didn't have any basis to find probable cause for a cell phone search warrant, to look at all data on a cell phone search warrant. If you don't even have that fig leaf to support that there's going to be a lot of data on this phone, police reasonably believing that we've established there's going to be a lot of data on the phone, then you don't get to the good faith exception. Then you're in the world of the Leon exception for cases where there is the warrant is so lacking in indicia of probable cause that police couldn't reasonably rely on it, which is what Burns held was the case for Burns. And I think that same holding applies here.
So help me with one more thing too, as I read your briefing, it's very strong on the point, or your client's very strong on the point that there needs to be some indication, and it didn't seem when you were arguing just a minute ago that your client was absolutely stuck on this point, but that there had to be some indication the phone was used in the crime itself as an instrumentality,
Right.
or at least some sort of proof or reason to believe, like specific, not the general knowledge that people carry their phones with them, that the phone was there.
Right.
Is that your argument?
Yes. And I think, just to be clear, we're not saying there has to be direct evidence in every case. I think that's a bit of a straw man that the government has raised. A good example of the kind of case where there wouldn't be direct evidence, but it would still be the particularized as to generalized basis to conclude that a cell phone was used for communications is the Hinley case from Massachusetts that's cited in our reply brief. And in that case, there were a number of facts in the affidavit that made it seem pretty clear that the defendant had been tipped off by a fellow gang member that right now in real time, this is where your rival gang member is located. And he went across town and shot him. And the court concluded that there, on those kind of facts, you could reasonably infer that it had to be a real-time tip, a real-time communication. And the most reasonable way that would have been done is by cell phone. But absent those kind of particularized facts and circumstances that show that the cell phone, not just generally that people use cell phones, because again, that would violate Riley's requirement that we have more than that you can't just rummage through every arrestee's cell phone, right? That would turn Riley's warrant requirement into a rubber stamp.
Would temporal limits help fix that?
I'm sorry?
Would temporal limits help fix that? Like if we believe that, okay, if you're going, we know that people carry their cell phones.
Right.
We know that they're constantly pinging and location data is being collected. And I recall on the record here, though the U.S. Attorney's Office didn't seem to rely on it as much, that the government presented some location data showing it. I think it was 9:48 and a couple other times the phone had pinged as present at the site of the crime. But if we know common sense, people carry their phones, it's got location data, has this whole trove of data. If it was limited and police were told you could only, if you're going to get a warrant, you can only look a day before, the day of, and the day after.
Mm-hmm.
And if you want to look any further or look into specific apps, then after you've had your initial look, you need to follow up and get another warrant. Would that cure any of your concerns?
I don't think so. And Burns has said that's not enough, right? Because Burns says to be compliant with the Fourth Amendment, the warrant must specify the particular items of evidence to be searched for. So that warrant doesn't really do that, the warrant you propose. And it has to be strictly limited, not just to the time period, but also to the information or other data for which probable cause has been properly established. So, you know, in Burns, the court said, okay, there's probable cause for some communications, some text messages, call log, and some GPS data. Police could have looked for that without having to go into the internet searches, without having to go into photographs. There was no colorable reason to think they needed to look in that information. So that's why you need more than just a temporal limit. Whether there might be circumstances under which a very narrow warrant for the, you know, the minutes or hour around the crime is a question for, I think, to be developed in litigation.
Let me ask you one more thing
right.
that I find interesting. To my knowledge, it wasn't available back then, but now police can and do buy collections of de-anonymized to a certain extent data that can be traced back to a person and can show a number of things that are sold commercially. I know there's a lot of concern and legislations being looked at about that issue across the country, but if it's available from another source, does that affect the reasonableness of the warrant or whether there should even be a warrant if they could go get it from somewhere? Not saying like they can go take the phone, but no, you shouldn't be able to take the phone. You can go get this from somewhere else.
Right. I think that does inform the assessment of you know, sort of the ultimate Fourth Amendment assessment of the reasonableness of the intrusion on the privacy of the cell phone owner. So if the government can get data that shows the same information without having to rummage through the phone, particularly if, as the government continues to maintain, you know, they believe it's necessary to look at everything in order to find even a narrow piece of data. We don't think that's supported by the record in this case or by the facts about cell phones or how the Celebrite software works. But particularly if that's the case, then the fact that they could get the information without having to do that search is certainly relevant to the Fourth Amendment inquiry.
Before you sit down, and we will give you a few minutes for rebuttal.
Thank you.
Let me ask you a question that you may think is off the wall, but that I've been thinking about. Suppose we reverse and remand for a new trial on the grounds you identified. Would the government theoretically perhaps be in a position to say, well, look, we seized the phone and that seizure was perfectly lawful. And we still have it, I guess. We still have all its pieces or whatever. Phone itself may be no longer in existence, but we still have it. Let us try to submit a new affidavit to justify a search of the phone untainted. We'd have to work this out, figure out a way to structure the affidavit so that it is not tainted in any way and could persuade a judge that it's not tainted by the unlawful search. If people were demanding, we found it unlawful. Could they do that?
Your Honor, that's not a question I've sort of thought much about or researched for this argument. I think, you know,
That's why I said it was all
right, giving them a second bite at the apple like that. You know, I don't think that would be appropriate. I also would point out that in this case, again, they can't show probable cause to believe that there were communications after the robbery occurred, which is where the only useful data arose. So I think any effort to more narrowly tailor the warrant to the probable cause would be fruitless on the facts of this case.
Well, that gets to another ramification that I wondered about, which is this. Let's say they have a valid narrow search, but they do have to look through the whole phone, basically. And what if they see things that in plain view while they're doing that search, they aren't covered by the warrant, but oh my God, look at this.
Right.
This really nails it. Now, what procedure do they, in your view, have to follow if that happens?
I think that's a thorny question. Courts around the country have struggled over whether the plain view doctrine, and commentators, I think Warren Kerr is the commentator who's suggested that it's not appropriate to even allow the plain view doctrine for digital searches because it is so easy to come across, you know, vast amounts of other information. At a minimum, for those courts in other jurisdictions that have allowed the use of evidence found in plain view, what the procedure that's been required is as soon as they see something that it is evidence of a crime other than what the warrant has authorized, is they go back to the court and they seek another warrant to look for evidence of that new crime. So you see that in some of
That's
the
interesting because in a home search, to take the paradigm Fourth Amendment example, if the police have probable cause to search a home for X, and in the course of doing so and carrying it out in a legitimate way, they come across, you know, obviously incriminating evidence that they had not anticipated.
Mhm.
I think I haven't had a plain view case recently, but I think they can seize that right away, can't they?
I think that's right. And here the evidence they come across is already seized. I mean, it's already in the government, the digital evidence that they would come
So
across
it's already in there.
is right, already in the government's
So that
possession. But to look for more of it, they would need to seek an additional warrant. Whether they can, you know, if
I
they
see what you're saying. So in other words, they can't change the scope of their search in your
Correct.
view, based on what they see without going back to the judge.
at a minimum, I think. And I think it would, you know, this court will need to consider in some future case whether even that is enough protection for the privacy interests. I just mentioned that one of the cases cited in Abney is the Maryland court's case Richardson, which has since gone en banc. And there's an interesting opinion there that sort of talks about some of the knock-on ramification. It comes to the same particularity conclusion that Burns did, and has some interesting discussion about, you know, plain view and what kind of limitations warrant judges need to be applying to make sure that the warrant is as narrow as reasonably possible, given the private information.
Let us hear from the government and then we'll give you a few minutes in rebuttal.
Good morning. May it please the court. Mark Hobel for the United States. Before I get started, I just want to know, because I think this is important, the Richardson case that the defense just mentioned was recently decided by the Maryland Court of Appeals, and they ultimately upheld the warrant on good faith grounds, just as this court recently upheld a very similar warrant on good faith grounds in Abney. just as the Fifth Circuit going en banc in the Morton case cited in our recent 28K letter decided a similar case on good faith grounds. And we think that in this case can also be decided on good faith grounds. The investigators, based on the state of the law in 2016, when they executed this warrant, were reasonably relying on the authority of the warrant issued by a superior court judge. And so we think the good faith doctrine applies and precludes suppression here.
But doesn't it really have much more in common with the Burns warrant than the one here than with Abney?
No, I think actually it has a great deal in common with Abney. If you look at the facts of Abney and the facts of this case, they're actually striking parallels between the crimes. In both cases, you have the suspect luring somebody who believes they can trust the suspect under the pretense of a drug deal to another location, where accomplices of the suspect show up with a car, using the car, assault and rob the victim, and then make off with the proceeds of the robbery. So
Those are the outside facts, but as far as it comes to the warrant, like I can see, and those outside facts seem to be the basis of you should read in a lot. But the warrant itself and the affidavit seem to ask us to read in a lot more than the Abney one. Could you address that?
I think that it did ask the warrant judge to make reasonable inferences from the facts in the warrant. That is, when you have a suspect lead a victim into what appears to be a coordinated ambush, a trap is sprung, the perpetrators move the victim to another location, stab and dump the body, make off with the drugs. The reasonable inference is they had to communicate about this crime to make it happen, to pull it together. And the probability is they use cell phones, because people use cell phones when they're trying to arrange a get together in everyday society. The warrant judge is allowed to draw reasonable common sense inferences from the facts in the affidavit in determining where there's a fair probability evidence of the crime is going to be found. That's Illinois v. Gates. And, you know, the warrant
Don't
judge.
the inferences have to be drawn though by the affiant so that the judge can understand what the thinking is? Here, the striking thing about the affidavit is that no inferences are drawn except the conclusory statement that unspecified evidence might be found on the phone. And the judge, in issuing the warrant, draws no inferences and simply says, well, I'm persuaded that evidence might be found on the phone. And the judge doesn't even, and the affiant doesn't even request, and the judge doesn't even identify any particulars whatsoever. Look for this, look for that. You may seize this, you may seize this, you may seize that. We want this, we want that. There's none of that. To me, that's a very striking feature of both the affidavit, which oddly enough is signed not only by a detective with some experience, I assume, but also an assistant United States attorney with experience. This is, I would have expected, I think, a little bit more in reasoning or drawing the connections or being specific in the affidavit. There's none of that. And I think that seems to distinguish this case from a case like Abney or many other cases. They at least say something. They at least say, the judge, here's what we think is there and here's why we think it's there. None of that here. That seems to me a big defect.
Right. And, you know, so I think that nobody is saying that this is a perfect warrant. What we are saying is that the facts give rise to a reasonable inference, a fair probability that evidence of this crime will be found on the phone. There are enough facts about the crime that, as in a case like Moats from Maryland, as in the Johnson v. State case that we cited in our 28K letter, which is extremely 2015 case that is extremely close on the facts and what was stated in the affidavit to this case, that an officer could reasonably rely on the warrant judge's probable cause determination to in exercising this warrant.
Is that true even if we don't know from reading either the affidavit or the warrant what the judge's reasoning was that led the judge to think there was probable cause? I mean, it's one thing, it seems to me, to say, well, if, you know, on appeal, you really study this affidavit, and you could really come up with a rationale for why there might be certain type of evidence on this phone. We can't tell from the record whether the judge ever, who issued the warrant, ever was asked to engage in or did engage in that sort of rationale. And for all we know, given the vagueness of all this, the rationale was simply, you know, cell phones have a lot of evidence. Let's get it all.
So with respect to the question of whether we know what the judge was thinking, the answer was no. And that's going to be true in basically every one of these warrant cases. And that's baked into the equation. You look at Illinois v. Gates, which says that on the probable cause question, before we even get to good faith. So at the first level of deference, the magistrate judge is owed great deference because these are spur of the moment decisions, often made under stress with imperfect information. And so the great deference bakes in that you have to defer to the reasoning and ask whether there is a substantial basis, not what did they actually rely on, but was there a substantial basis here to find probable cause. And that substantial basis can be provided by reasonable inferences related to the facts of the crime, as in Moats v. State from Maryland, which was a sort of a contemporary case that so, you know, going to the reasoning of Abney, you know, if you look at the state of the law at the time, it's not enough for them to say this court has never did not decide the issue. There wasn't any clear law in this jurisdiction. It was muddy and thorny. If there are persuasive precedents on both sides, the officers can rely in good faith on the warrant judge's determination. And here we've provided cases. Many of the cases cited in Abney itself stand for the proposition that a warrant like this one, maybe it's close to the line, but it's not so far over the line that good faith isn't going to protect reliance on that warrant.
I do think, though, some of the cases from other jurisdictions you rely on, this is definitely true in the probable cause question, where you might make these arguments, but after Burns, it's hard to make them. But I think that also arguably affects the good faith analysis. If you're relying on cases where the good faith exception was accepted, but there was no case like Burns that sort of was the first case that set things out as a baseline and the guideline. It just seemed, I'm not sure how persuasive those are.
Okay, if I understand your honor to be saying that Burns was sort of a first case that set the baseline and the guideline on dealing with some of these overbreadth issues related to cell phone warrants, we agree with that. It was largely a case of first impression that relied almost totally on its reasoning on Riley v. California. And all Riley said was you have to get a warrant, didn't say anything about what needs to be in the warrant. So there really was no operative clear guidance for the officers in the field, for the Superior Court judges having to issue warrants on short notice in 2016. There may be now. And my argument here today, really, this case can be decided on the same narrow ground that Abney was, which is that in 2016, even more so, but it doesn't have to be, than in 2018, given the state of the law at the time, a reasonable officer submitting this warrant to the judge signs it, a reasonable officer can rely on that warrant. You know, with respect to the particularity and the overbreadth issues, Ms. Terrell said, you know, the scope of this warrant was the same as Burns, the same as Abney. And I don't know that she meant that as a concession, but I think it is close to a concession, because Abney said in 2018, before Burns was issued, there was no clear guidance on particularity and overbreadth in this jurisdiction. And cases from other jurisdictions There were persuasive authorities from other jurisdictions that said a warrant that a warrant to search a suspect's cell phone that indicates you can only see you can seize evidence of a specific crime described in the affidavit. That satisfies particularity and overbreadth concerns.
But that's not what we have here, is it? Like this is my problem when I look at it. We've got a lot of scenarios where we provide a lot of deference. You know, if you looked all of us before, you would see my background is primarily in administrative law, or at least my recent background, and we provide a lot of deference there. But we require some sort of explanation, something to lean on. We don't fill in deference for folks usually. We don't fill in the blanks, fill in the conclusions. And as I look at the search warrant, all it says is all data files. I mean, it's drastically different than ABNY. And there's a lot of fill in the blank on the affidavit too. Like there's nothing here that says specific crime. Like, can you help me get there?
Mm-hmm. So I think the argument that Your Honor is making, based on the question Your Honor is asking, based on the face of the warrant, you'll note that it says at the beginning of the warrant, affidavit herewith attached. So the affidavit is coming attached to the warrant. It is incorporated into the warrant. And under this court's decision in United States v. Moore, and I don't know that case is in any of our briefing because I don't think this precise issue has come up, but I can provide the pin site now. It's 263 A2D 652 DC 1970, and I'd be happy to submit a 28K letter if you'd like me to with that authority. Or that says that if the affidavit required for the issuance of the warrant is attached to the warrant and incorporated therein by reference, it can be used by the officer to identify the place intended. So here we have the affidavit attached describing the facts of the particular crime, the ambush and robbery and stabbing of the victim, and it even references the arrest warrant that was signed by the same judge a few days before, charging the defendant, I'm sorry, with assault with intent to kill and the assault of the victim. So like ABNY, and the defense is not arguing otherwise. They've said the scope of the warrant is exactly like ABNY. This warrant authorizes the authorized investigators to search the data in the phone for evidence of the specific AWIC crime here. And again, under ABNY's reasoning in 2016, just as in 2018, there wasn't clear authority that would have put those officers on notice, obviously, that in this jurisdiction that was a facially defective and illegal warrant. In fact, there was plenty of authority to suggest that was consistent with the law and they were following the law. So we think the good faith doctrine applies there. One more point I would like to make about good faith. Suppression of a warrant, suppression of evidence seized pursuant to a warrant is unusual and rare. The Supreme Court has said it's unusual and rare in its case law. So Burns is the exception and ABNY really is the rule. So to the extent that this case is, there may be differences between this warrant, this affidavit, and the ABNY warrant and the affidavit. That's going to be true in every case because they're all different on the facts. And we think the forest, in a way, the similarities overwhelm the differences. But even if you see minor differences, again, most cases are going to follow ABNY. Very few cases are going to follow Burns. And we think this is a case where even if you believe that the warrant should have been significantly narrower, even if you believe that this judge shouldn't have signed this warrant because there wasn't enough probable cause here, the judge signed the warrant, the officers reasonably relied on it, and we don't think that suppression pays its way here. And I see my time is running out. Unless the court has any additional questions for me, we would ask that this court affirm Gibbs' convictions.
Before you sit down, I've been trying to think in my mind about a hypothetical, always a bad sign, involving the search of a home rather than a cell phone. Suppose the warrant in this case said something like, well, the perpetrator here had a weapon and also got away with there's evidence that he got away with marijuana and who knows what else. It could be in his home. People do, we have a lot of experience with people who take their proceeds and their weapons back to their homes. We find them there all the time. And the magistrate authorizes a search for evidence in the home without even specifying what the reasoning is, like in this case. Or would your argument stand up that that search warrant, that an officer could in good faith search the home with using that warrant?
Yeah. You know, it always involves, I think the answer is probably yes, but it always, and I'm not sure that it's based as much on my logic here as it is just on case law that I'm familiar with. I mean, we cited in our most recent 28K the Orozco case from the Fourth Circuit, which itself cites an older Fourth Circuit case called United States v. Anderson, which involved the Fourth Circuit upheld a home search based on allegations in the affidavit that the suspect was seen with a gun outside the home. And there was no direct link to the home itself, but on that basis, a warrant was authorized to search the home. I think the Supreme Court's opinion in Messerschmitt v. Melender from about 10 years ago, which uses the same standard and qualified immunity as the good faith exception, that also involves some fairly similar facts. So, you know, again, all of these come down to the totality of the circumstances, and I'm hesitant, and this is, as the court said in Gates, this is not an area of the law that lends itself to bright line rules, but I'd say probably.
No, but the court said in Burns basically that, look, there are some things everybody has to understand. You need probable cause and you need particularity. And there is some probable cause here set forth in the affidavit. And I think the argument could have been made for a somewhat limited search pretty readily. But the notion that Leon is the norm, and therefore that, anytime a magistrate blesses it, the officer, the search is, okay, on a good faith analysis, I think runs up against that basic point in Burns, because here there was such a clear absence of any sort of particularity and reasoning and justification for the search of the phone in the affidavit. It just seems like this is one step too far in that regard. Anybody would know you're supposed to give the judge reason to believe there is evidence in the place to be searched, and what that evidence is, and if necessary, where in the place you're going to search for it.
So I want to be really clear about something that was in your question there. We're not saying that any time, we are definitely not saying that any time a magistrate issues a warrant that the good faith exception applies. That would run straight up against Supreme Court precedent. We are saying that the Supreme Court in Messerschmitt said it's going to be rare. It is going to be rare that reasonable jurists are all going to come out on one side of an issue against the issuing judge. It's going to be rare that a warrant is so facially defective that a simple glance at it is going to put the officer on notice that it is that they can't rely on it. It's going to be unusual and rare, and ABNY is consistent with those Supreme Court precedents. And I think that Your Honor said, look, there's some probable cause here based on the common sense inferences about how people use cell phones that emanate from that come from the specific facts alleged in the affidavit. The warrant judge having signed the warrant, it was reasonable for the officers not to second guess that. Now, maybe the situation, I think without even getting it, well, I think Burns did.
Let me put my point. If the magistrate had issued this warrant and the warrant said, you may search for the following types of evidence. Evidence showing that there were communications between Abney and people at that time. Photographs of knives. Yeah, you know, come up with whatever. If the affidavit had been, if the warrant had been specific in that sense, I think the case would be more like Abney, and I think it would be a justifiable to say, well, the officer could rely on good faith, because you can see the process of applying for a warrant did what it's supposed to do. The magistrate judge clearly thought about what this evidence signified, whether it showed probable cause, and identified what the officer is allowed to search for. But here, the affidavit simply says you can search for data files. Maybe some other stuff I've forgotten now, but it doesn't even tie. It shows nothing like the kind of process that the warrant application is supposed to, you know, generate. That seems to me have a bearing on whether the good faith rule applies.
I think it would have been, I'm not disagreeing, it would have been better. It would have been better, and it would have reflected, it would have reflected more process and more diligence. That may not be reasonable always to expect in a.
There was no rush here. There was no rush here. They had the phone.
Well, but respectfully, Your Honor, there were multiple unidentified perpetrators who had nearly killed a man, and the detective wanted to know who they were so he could, so they wouldn't pose a threat to anybody else.
Well, by no rush, I mean, an extra half hour would not have made a difference.
Taking your point, Your Honor, this wasn't a perfect process, but it was a process, and it was an outcome that was consistent with warrants that courts had upheld at the time. So there's always, under Illinois v. Gates says, essentially, there's always more that can be done. There is always more that can be done to make a better warrant, but that's not the standard. The standard is there a substantial basis to issue the warrant on probable cause? And then when the officer gets the warrant, is it so obviously defective, so obviously bare bones that no reasonable officer could rely on it? So the standard that I think you're espousing is a standard that we aspire to, but it is, I think respectfully, Your Honor, it is not the standard that we apply when we are asking whether evidence should be suppressed, and it's not the standard that this court applied in Abney, and this court was correct to come out the way it did in Abney, and effectively we think that this case.
You're well aware that two of the judges on this panel were on Abney.
I'm well aware, Your Honor. So
well, one final question. We may have already answered, I suppose, but we're back in 2016 when this application is submitted to the magistrate. What is your best case for the proposition that a warrant like this was not an affidavit of warrant, but it was not beyond the pale, but could reasonably support the issuance of a warrant and a search?
In terms of the closest facts, I think the Johnson v. State case from Arkansas, and
Johnson v.
State from 2015, the Arkansas Supreme Court. Gillespie v. State is a 2016 case from Georgia that is also in our 28K letter, and that involves similar inferences, although that's drug-based. There was a pretty similar murder in the Johnson case, and the court found probable cause based on inferences. There wasn't any training and experience line, based on inferences from the facts of the crime and the group nature of the crime, and for a search of essentially all the data in the phone to find evidence of the crime. The only slightly meaningful difference, to be fair, between Johnson and this case is that there was, I think they found the phone, or they got the phone the next day, but we don't think that the 6-week delay, and we put this in our briefs, meaningfully detracts from probable cause. In this case, it's still reasonable, and Abney noted months and years that people hold cell phones. It's still reasonable. So we think that's a fairly consistent case goes to the point about could officers reasonably rely on this given the state of the law at the time.
Can I ask you one last question? You say that you think that the court came out the right way in Abney, but I keep having the sense during some of your arguments that you're resisting Burns. Do you think the court came out the right way in Burns?
Force yourself.
Yeah. I maybe I'll leave it to Ms. Darrell to discuss the reasoning in Burns on the good faith question. That is something obviously we argued that good faith should apply, and we did actually petition for en banc. What I'd say again is I think that the reconciliation comes here from the principle that suppression, when you follow a warrant, it's not automatic that it won't follow, but it is unusual and rare, and so Burns is going to be an unusual and rare case, and Abney is much closer to the norm.
Yeah, I have one more thing out in left field that I'm curious about.
Sure.
And you feel free to tell me you don't know the technical aspects of this, but it is a technical question. When your folks at the police department go about getting this data from the phone and all, they end up destroying the phone, right?
That's what happened in this case. I don't think that's necessarily. I don't think that's going to necessarily be the case in every even most situations. That's sort of beyond what I know technically at this point.
Is the data preserved and turned over to the person whose phone's destroyed when a phone is destroyed?
Oh, yes. In terms of discovery, yeah, our standard practice would be to disclose if we are extracting data from a suspect's cell phone, and there's essentially a report that's generated of that information in readable form using a program like Cellbrite. That Cellbrite report is disclosed to the defendant.
So I'm not asking about a Cellbrite report. Like what was said in this was when they pulled the memory chip off, it was imaged, meaning that they went and made a copy, not like, of ones and O's, but literally like took a picture of the thing, much in the way that you may have burned a CD back in the day or done some other things with a program like Nero, for instance.
Yeah.
That image would allow me to load on a memory card everything back. And if I was Mr. Gibbs, to have my text messages again and be able to use my phone and not have all that data that's such a part of my life forever gone. Are the images turned over, or this is completely, again, in left field? And
yeah, so I think and again, as I understand the technology, and I have dealt with this a little bit, the image, the file that is extracted before it's turned into readable form using a program like Cellbrite, it's bits and bytes. It's not something that Mr. Gibbs is going to be able to look at and say, okay, I remember these photos and this and that. The Cellbrite obviously is something that's digestible to.
yeah, I'm not concerned with him
right,
being able to digest it. I recently switched phones,
Yeah.
and luckily my phone lets me plug it into the old phone, and since they were the same type, I can transfer everything over and go on about my life as though very little has changed, except for the annoyance of having to log back into everything again and hope I don't lose access to anything. I'm asking a more functional question of, is some backup made such that when someone's phone is seized, they don't have to completely recreate their digital phone life from scratch?
So I'm not sure I know the answer standing up here to the second part of that question. The file is made that extracts all the data. So that file, and I am aware of situations in which I believe we've turned that file over to the defense in certain cases so they can retain their own experts. Some defense attorneys want to do that. So that file is there. Whether that, and of course, whether that then is something like in your honors, when you're saying I've done this too, gotten a new iPhone and you can kind of put it up against the other one and it'll transfer.
Android.
I don't Android. Okay. I don't, I actually don't know the answer to that question.
Okay. Thank you.
Thank you all.
Thank you, counsel. Ms. Terrell?
Thank you, Your Honor. I'd like to just answer Judge Beckwith's last question first, which is that Burns absolutely did get it right on overbreadth, on particularity, on probable cause. And the clear guidance to police on what a warrant required in 2016 in this case was the same as it was in 2015 in Burns, and that's summarized in Burns at pages 771 through 72. There are a plethora of venerable Supreme Court cases establishing that, you know, if there's one thing that warrants do, it is to restrict the search, any search, to only those items and only those places for which probable cause has been shown based on substantial facts to the warrants judge. That
Does
was
it
not
potentially heighten the review in your standard, or heighten the concern in your view that unlike a home where I choose to store a gun, drugs, or anything else, that there is data I have no control and at times no knowledge of, or that a reasonable person wouldn't be able to necessarily ferret out, much in the ways we talk in cases about not applying a legal technician's view to this probable cause standard, a technological technician's view. There's data on a phone that I just don't necessarily even know is there or have a choice about.
Yes, that's definitely a concern. I mean, I think the concern that the Supreme Court identified is that phones contain a vast trove of information, more than you would have in your home. So, you know, to use Judge Glickman's analogy, you know, the warrant here would be like saying, okay, we've arrested someone for a stabbing. We think the knife might be in his house. Please give us a warrant to go look in his house for the knife and for any and all other evidence of the crime. We're going to read his journal and see if he wrote about it. We're going to go through his mail and see if he wrote to any friends about it. We're going to look in his photo album to see if he took pictures of it. And with cell phone warrants, even we'll go beyond the house. We'll go to his doctor's office and look at his medical records. We'll go to his bank and look at his financial records to see if he's sold the proceeds of the robbery. It is exceptionally vast and sweeping. And I want to be very clear that Burns got it right on the notion that just limiting a warrant like that to search for evidence of a particular crime is not sufficient. Given Burns's holding and given the fundamental Fourth Amendment principles on which it relied, Abney cannot be read to mean that a warrant limited to evidence of a specific crime could be relied on in good faith before Burns was issued. That would create a big MAP versus Ryan problem. It certainly can't be relied on now after Burns has been issued going forward. Briefly, the cases that the government mentions, none of those should change this court's analysis. I mentioned Richardson to the court because its particularity analysis is very informative, but its good faith holding relied on exactly that rationale that Burns has rejected, which is that the police could rely in good faith on an all evidence of this particular crime warrant. That ship has sailed in this jurisdiction for warrants post Riley, not post Burns. Morton has a number of.
It might depend on how specific the crime is. There might be some crimes where it would be sufficient to say specific evidence of this crime, whereas other crimes that would just be too.
Sure. There might be, you know, some elaborate complex case like the Dread Pirate Roberts case, the Ulbricht case out of the Second Circuit, where it was a vast, you know, computer conspiracy and fraudulent scheme where the evidence pervaded the computer, and it was not reasonable to state with more particularity what it was that the police were looking for. But for most warrants that issue in this jurisdiction, for most cases, that's not going to be the case. And I think Richardson talks about that there's only a few kind of cases where this sort of all evidence warrant would be appropriate. Briefly, the Fifth Circuit decision in Morton expressly declined to follow Burns, so it isn't particularly useful guidance, the majority opinion. I would direct this court to the concurrence and the dissent, which I think are in line with the arguments that we're making today. Neither Gillespie nor Johnson raised a particularity challenge at all. So that doesn't even, you know, sort of granting the government its tenuous probable cause argument, that still doesn't get them outside the rule of Burns, which is that these warrants were lacking in particularity, obviously overbroad, and therefore could not be relied on in good faith. And we'd submit that the Abney really sketches the outer bound, given Burns's good faith holding of where an all evidence warrant could be relied on in good faith. And that's where there is really some meat in that warrant affidavit to suggest not only that there's some evidence, some limited bit of evidence on the phone, which we don't even have that here, but a great deal, a broad range of evidence on the phone. And that's what the court highlighted in its final paragraph in Abney of the good faith discussion at page 867. This case was different from Burns. There was probable cause to believe that Mr. Proctor had participated in the robbery, but it doesn't stop there. It says, and as we've held in the preceding section, the officers in this case could reasonably have believed that the warrant established probable cause to believe the cell phone seized from Mr. Proctor contained a range of relevant evidence. You have to have that at least colorable, arguable probable cause to believe there's a bunch of evidence on the phone in order to narrow this gap between the all data warrant and the showing of probable cause.
I would say that the argument could have been made that there was a range of possible evidence likely, that there was a range of possible evidence likely to be found on Mr. Gibbs's phone. Had it been sort of articulated, I think they could have articulated that. There could be communications leading up to the offense. There could be communications after the offense between the perpetrators. There could be locational data. There could be communications relating to the victim. There could, and the defendant's knowledge of the victim. There could be all sorts of photographs and the like. I would think that there could well have been a valid affidavit identifying a range of evidence that could be found on the phone in this case.
Well, again, I think
And the government says that if I think that, that's enough for good faith reliance, because we have to assume that, well, the magistrate judge must have thought that too.
I think Abney should be read to mean that's not enough for good faith reliance, as should Burns and the Fourth Amendment cases it relies on. You know, for all the reasons I've talked about before and in our reply brief, a search warrant for a cell phone can't rely on generalizations about how people use cell phones. And that's what you have to rely on to get communications after the crime, to get photographs, certainly to get web searches and things like that. So
that's what that is a position that does sort of give me pause. If we can say it as a matter of common sense and common experience that people use phones in a certain way, phones cover every aspect of their lives, they're really a window into people's lives, then why can't we, and indeed that's why we think it's so important that warrants be applied for and the like, then why can't we also apply that same reasoning when we look at a particular fact situation to determine whether there's probable cause to look for the certain things on the phone?
because that would turn every arrest warrant into a warrant to search a phone.
Yeah, it might.
In
It might,
violation.
but what's wrong? But the question is, what's wrong with that if it's factually valid?
Well, what's wrong with that is as Burns pointed out, is that Riley wasn't creating a paperwork requirement. Riley wasn't creating a requirement that a warrant judge rubber stamp police rummaging through every arrestee's cell phone for evidence of the crime. It was requiring a meaningful constraint on authorities' ability to rummage around in a cell phone because of the very sensitive and vast scope of private information, on the unprecedented scope of information that would be exposed to the government in the search of a home, in the search of a cell phone, far more than in a home. So Riley says you need a warrant requirement, and that means something. That doesn't just mean the police have to cut and paste the arrest warrant into an affidavit, say he had a cell phone, and get a warrant to look through everything. There has to be something more. In Abney, there were two things more that were missing in Burns and that are missing here, which is evidence that the cell phone was used as an instrumentality of the crime, and also an assertion, which again, we would say is sort of the bare minimum for good faith reliance, an assertion from a police officer that in his training and experience, not just, people tend to use phones so we can infer there would be information on anyone's phone of whatever they've been up to, but that people who commit crimes in the District of Columbia tend to use their phones in ways that create text communications, email communications, pictures, recordings, web search history. Here, without even
So if we have-
that,
Well, it is a funny thing, isn't it? So we have a case which says that,
yes,
where the affidavit said that. So why does every affidavit have to say it if we've now recognized it as a fact of life in the District of Columbia?
I posit that every affidavit doesn't have to say it, and even if it did, that wouldn't be enough.
Right?
Post Burns
Right.
for probable cause to search for those items listed, and certainly not for all evidence on the phone. But what it is necessary for is to get the government over the good faith hump. In a pre-Burns, post Burns, I don't think a warrant can pass good faith even with that claim. But pre-Burns, they at least need that kind of a claim to support a reasonable belief by the police that there's going to be a lot of evidence on this phone related to this crime. And so that's why it's okay that we have a warrant authorizing a search for all evidence.
Pulling you out into left field, if there's this danger of loss of data, destruction of it that we were talking a little bit about before, should police also have to present to the judge, and should the judge be considering before issuing that warrant, specifically how they're going to pull data off the phone and what they're going to do with the device?
I think a number of courts have required, sort of cell phone search protocols. I think some of those are discussed in the Richardson case. Some courts have required that, others have not. I think, again, that's a question to be addressed in further litigation before the Superior Court and ultimately here. But at a minimum, what we know is that this kind of all evidence, look for everything everywhere in case there's something useful warrant, that's basically just a fishing expedition, a general exploratory rummaging. And if a police officer knows anything now, if they knew anything in 2016, if they knew anything in 2015 about what warrants require, it is that about what the warrant clause means, it is that police cannot engage in that kind of general rummaging through a home or through a cell phone. And so for that reason, we would ask this court to reverse.
Counsel, thank you both. The case is now submitted. We'll call the second case on the calendar, in Re Robert Wolfe. Counsel.
May it please the court, Jennifer Williams on behalf of appellant Robert Wolfe. I would like to reserve 2 minutes of my time for rebuttal. I would like to discuss both of our issues today. First, I'll address our argument that Mr. Wolfe's prosecution was a private action. Next, I'll address the alternative argument that if it was a public prosecution, the prosecutor was not disinterested. 2 years before Mr. Wolfe was prosecuted, the court held in Robertson 1 that CPO contempt prosecutions were to be brought in the name and interest of petitioners, and were not executing the criminal laws of the land, but only securing to suitors the rights which it had adjudged them entitled to. Consequently, Mr. Wolfe's prosecution was a private action under the control of Ms. Korbach acting in her personal interest. As this court held in Taylor, allowing private citizens to harness the machinery of the criminal justice system for their own personal ends is structural error that undermines the fairness and integrity and public reputation of the proceedings. This court must reverse.
In Robinson 2, the court did a 180-degree flip and said, oh, it wasn't a private prosecution. It was a prosecution in the name of the United States. And if the court could say that retroactively in Robertson 1 about, retroactively in Robinson 2 about Robinson 1, why doesn't that also apply retroactively to the prosecution here?
Sure. So what the Robertson court said in Robertson 2 was that at the time of Mr. Robertson's prosecution, the law was clear that any prosecution had to be brought in the name and interest of the United States. So whereas in Robertson 1, they said it was a private action, in fact, it would have been understood to be a public action. So that was a commentary on the state of the law at the time of Mr. Robertson's prosecution. Robertson 1 intervened between Mr. Robertson's prosecution and Mr. Wolfe's prosecution. And what Robertson 1 said is that this is not a action in the name and interest of the United States. This is not a public interest action. This is a private action in the name and interest of petitioners. And it acknowledged all of the law proceeding that said that that prosecutions have to happen in the name and interest of the United States. And it said that because of the unique statute governing interfamily offenses and the special situation of criminal contempt prosecutions, this is of a different nature. This is a different kind of prosecution. And this prosecution is not enforcing the general criminal laws. It is for a petitioner in that petitioner's name and interest. So when Mr. Wolfe was prosecuted, everyone was following the law according to Robertson 1, which the Robertson 2 court then corrected. But in that band of time between Robertson 1 and Robertson 2, those prosecutions took place as private actions in the name and interest of petitioners. Even though we now know that's unlawful, that was the state of the law at the time of Mr. Wolfe's
So the
prosecution.
argument that you're making wouldn't apply pre-Roberts 1 and it wouldn't apply post-Roberts 2.
Exactly.
So you don't think that's exactly what they were thinking at the trial, Robertson 1?
At the time that Mr. Robertson was prosecuted, no, I think that it's true. The law did say that prosecutions have to be brought in the name of the sovereign. That's the only authority for bringing a prosecution is in the name and interest of whatever the governing sovereign is. That was the state of the law at Mr. Robertson's prosecution. That was recognized in Robertson 2 as the state of the law. And so, you know, captions aside, that is what everyone would have understood happened. But at the time of Mr. Wolfe's prosecution, that was not the state of the law. There was an intervening case on point that said this is a private action, regardless of what you might think of what a prosecution should be. So,
But weren't there features of the prosecution when it occurred in Robertson 1 that made it look like a private action rather than a public action?
there were some features such as, you know, the captions. It was in the name of Miss Watson, or rather Watson versus Robertson, and here it's, you know, Korbach versus Wolfe. But I think that's important to consider. And again, I know that the government has emphasized the fact that there was an assistant attorney general at both trials. But it's important to recognize that the Interfamily Offenses Act authorizes assistant attorney generals to wear multiple hats. Sometimes they wear the hat of the government, and sometimes they wear the hat of the personal attorney for a CPO petitioner. And so at the time of Mr. Robertson's prosecution, having an assistant attorney general there, that assistant attorney general was representing the United States as they are, or rather the district. But at the time of Mr. Wolfe's prosecution, there was a different hat on that assistant attorney general. She appeared as the attorney of Ms. Korbach. That's how she identified herself.
In Robertson 1, how did the attorney identify?
I haven't looked at the transcript of Robertson 1. I am aware of the caption issue because that's discussed.
And wasn't there case law before Robertson 1 and before the trial in Robertson 1 that described the contempt proceeding as a proceeding brought by the private party?
So there is Green versus Green, but as we said in our reply brief, and as the Robertson 2 court said, Robertson 1 sort of took Green a little further than it actually went. What Green actually said was, you know, that a petitioner in a CPO action can sort of initiate a prosecution, but that doesn't mean that it's brought in their name or in their interest. So that sort of question of the private action.
Well, if you combine it with the fact that the case was brought in the name of, in this case, Korbach and well, Quebec, right?
Quebec.
I may not be pronouncing that correctly. And in Robertson 1, it was brought in the name of the complainant there, whose name I forgot. You know, I just want, it's a very funny thing we did in Robertson too.
Yeah.
But you just wonder whether one can, I mean, I grant you, this fits in between, in the period between Robertson 1 and Robertson 2. So everybody at the trial of this case might well be presumed to have thought of it in the way Robertson 1 characterized the case. I take that point. The thing that bothers me is that may be exactly true of the trial in Robertson 1 also.
So I think that
So they
we,
didn't have Robertson 1's opinion
exactly,
at that time.
that is the sort of intervening difference. Robertson 1 was an opinion exactly on point to tell everyone who had control over this prosecution. And the answer given in Robertson 1 was, this is a petitioner
See, I'm
action.
wondering whether this point really goes to your second argument, which is that there was not disinterested counsel representing or prosecuting the action.
So those our two issues are essentially alternative issues. We believe that Robertson 1 is very clear on the fact that these CPO contempt prosecutions fall outside of the traditional universe of prosecutions and have to be treated as private actions. And that is its own kind of error. If this court disagrees and believes they're public actions, which would essentially be the court disobeying the holding of Robertson 1, if this court believes this is a public action, then certainly there was not a disinterested prosecutor, because the prosecutor was contemporaneously representing the petitioner in the underlying CPO.
Maybe this question goes to both issues or both parts of your position. Suppose the Attorney General, the Office of the Attorney General, concludes that its interests fully align, that its position and interests fully align with the position and interest of the complainant in the contempt action, and therefore take the position there's no conflict between them. The Attorney General, there's no reason why the Attorney General's office can't represent, in effect, both the United States and the complainant in bringing the contempt action. If that's the position that the Office of Attorney General takes, does that suffice in your view to put the issue to rest and satisfy the disinterestedness criterion?
No, Your Honor. And just so I'm clear, we're talking about if this is a public prosecution that happened to have the Office of the Attorney General representing the petitioner, or rather representing their interests and also the interests of the petitioner.
Suppose we, for example, view in this case, the Attorney General representing both the United States and Ms. Corback having satisfied themselves that there's no conflict. We're not adverse to each other. Our interests are the same. Attorneys sometimes do that. They sometimes represent multiple parties. And suppose that was the position, wasn't articulated, I don't think, on the record. I grant you that. At least I'm not aware that it was. But suppose that was the position of the Attorney General here. Would that allay your concern, or would that be an answer to the argument that counsel prosecuting the contempt proceeding was not disinterested?
No, Your Honor, I think for a variety of reasons. First, I think just the nature of the conflict means that it would be, I think, difficult. I think it would be impossible for a prosecutor to say at the outset of the case, for the entire duration of this case, every single aspect of this case is going to align perfectly with the interests of the petitioner in this matter, because, well, I just don't think that that is a possibility. And I think that the discussion of this kind of conflict in Young is very sort of explains why this is such a problematic conflict, both for the appearance of propriety and also for the actual experience of the trial. The Young court said that in a case where a prosecutor represents an interested party, the ethics of the legal profession require that an interest other than the government be taken into account. The government's interest is in dispassionate assessment of the propriety of criminal charges. The private party's interest is in obtaining the benefits of the court order. While these concerns sometimes may be congruent, sometimes they may not, and a prosecutor may be tempted, well, I guess that wouldn't apply to your scenario, to bring a tenuously supported prosecution. They clearly, in your hypothetical, they support the prosecution. But I think that the discussion of this kind of conflict in Young sort of captures why this is problematic for both the appearances of propriety and also just the purpose of a prosecutor who is supposed to wield the power of the criminal justice system's enforcement power with rigorously disinterested fashion. And that I don't think is possible if they are wearing the hats of representing both the interests of the petitioner and the interests of the government. And another thing to point out is that's why we have ethical rules that say that you can't do this. This would sort of fly in the face of the ethical rules that say that you have to, zealously represent your client, and also the I think 3.8 rules of professional conduct that say that the prosecutor is supposed to essentially ignore all outer influences and focus exclusively on the objective and neutral interests of the United States.
Is it instructive at all that in other similar scenarios, the example I'm thinking of in particular is under the DC Human Rights Act, the Office of Human Rights has a duty to represent the complaint. Basically, it's probable cause finding and be a public prosecutor of sorts, purely civil with no sort of criminal aspects to it in that scenario. At the Commission on Human Rights in the administrative process when those complaints are being put forward. Well, I won't complicate it with talking about the Office of Attorney General and Housing, but in those scenarios, this court in my memory has at least implied before that in representing the complaint or the public interest, that the Office of Human Rights acting as the public prosecutor in this scenario has to take into consideration the interest of the complainant as well.
So I'm not familiar with that area of law, but yes, Your Honor, I think that would sort of speak to this issue of the nature of the conflict.
That these things are just very hard to divorce, period.
Yes, I mean, it's not only is it very hard to divorce, but it is ethically required that you not divorce, that you keep in mind your interests of your client in all things. And I don't think that there's possible to be a guarantee that the interests of the client are always going to align with the United States. And I'd like to just briefly address the remainder of the plain error prongs.
Excuse me, I'm sorry.
The remaining prongs of the plain error analysis, specifically prong 4.
Specifically, oh, well,
Oh, or we can go
I
to.
thought you were going to go prong 4, but you could start at 1.
So on prong 4 of the disinterested prosecutor issue, we just like to say that when an error is structural, we know from Barrows, we know from Taylor that already gets you most of the way to finding that the fairness, integrity, and public reputation of the proceeding was sort of affected. Because structural errors by their nature, they pervade the entire prosecution, and they sort of inject unfairness into every single aspect of the proceeding. And so we know that in the vast majority of cases, this is going to meet prong 4. And here we have this language from the court, the Supreme Court in Young, that says that this is a particularly embarrassing, a particularly problematic issue in terms of the reputation, the public reputation of the court. What is at stake when a conflicted prosecutor is assigned is the public perception of the integrity of our criminal justice system. And prosecution by someone with conflicting loyalties calls into question the objectivity of those charged with bringing a defendant to judgment, and thus undermines confidence in the integrity of the criminal proceeding itself. That's the language of the court in Young. And so
Suppose we were able to look back at this proceeding and say, well, we don't think there actually was, and now that we have actually seen how it went, we don't perceive any actual conflict between Ms. Korbach's interests and the interests of the United States or the government. I guess that actually that raises two questions, I guess. One is, do you think that position can be sustained, that we don't see a conflict? And two, whether hypothetically or actually, if there was no conflict, would that make a difference to the outcome here?
So this court can't look at the record and determine, so what we see in the transcript is just a fraction of the prosecutorial role. We don't know the impact that Ms. Korbach could have had on charging decisions. We don't know the impact that Ms. Korbach could have had on the nature of the sentence that was requested. What we do know also is that in a case that from around the same period in Jackson, you had the U.S. Attorney's Office, which is a neutral prosecutor, looking at a situation where you had I think there was violence underlying the original civil protection order, and then there were 4 violations of that CPO. And there was a motion to adjudicate Mr. Jackson in contempt, and the U.S. Attorney's Office said, we don't want to do that. That is not useful. That's not useful for the use of the resources of the United States Attorney's Office. Let's just see if he gets into compliance with the CPO, which is what led to what happened in Jackson, where the court prosecuting Jackson himself.
Though it is interesting that the United States Attorney's Office's declination, and even if combined with the Attorney General's declination, is not the end of the inquiry. The judge can appoint private counsel to stand in for the United States. Which raises interesting questions, but so it's not, at least under our current law, it's not definitive that the United States Attorney's Office declined prosecution.
Sure. I mean, it is just sort of a comparison to Jackson. It's certainly not definitive. I think it is instructive. I think it's revealing about the priorities of the prosecutor at the time. But, you know, even privately, as the court knows, a privately appointed prosecutor would not necessarily have to bring the prosecution. They would just have to assess whether or not the prosecution is worthwhile. And then at that point, it would move forward.
In a privately appointed situation, the client for the private attorney is presumably the United States. Now, the private attorney themselves is not, or not the United States. They don't hold any position with the United States. How does the private attorney go about determining what's in the United States's interests, what the United States wants done?
I agree that
Who
that
do they
is.
talk to?
I agree that is a bit of a wrinkle in the
President
concept
United
of.
States, for example, that would be too much.
Yes.
The Justice Department is just declined to be involved.
I think that I admit that goes a little bit beyond the scope of the briefs in this case. I don't know. But I do think that there would need to be some assessment by a neutral prosecuting authority that this is a worthwhile prosecution and use of the court's time. And that didn't happen in this case. And just to the prongs of the rest of the plain error prongs on our first issue, that this is a private action.
But when you say it didn't happen in this case, suppose I'm just speculating now, suppose the Office of Attorney General agreed with you and said, okay, well, you know, the attorney, whose name I've forgotten, who brought the civil protection order cannot be the prosecutor here. But we have lots of prosecutors in our office, and another prosecutor can be. Why is that prosecutor not disinterested?
So we believe that the Jackson court and actually the finding of conflict in this case by Judge Lopez, when this conflict was originally raised, shows that when the Office of the Attorney General represented the petitioner in the underlying CPO, that office is ineligible to provide a disinterested prosecutor. That's why the procedure for initial assignment of these kinds of cases changed in the aftermath of Jackson in the in the Superior Court, these cases were now in the first instance, if the Office of the Attorney General represented the petitioner in the underlying CPO, then in the first instance, these were referred to the office, to the U.S. Attorney's Office.
See, what I'm wondering about, I guess, is if the issue were actually a conflict of interest, then I think the whole office one can see why I'm sort of in uncharted territory here, so I may be saying things that aren't correct, but yeah, one could see why the Attorney General's office would be disqualified. But where it's more a question of, well, can a disinterested decision be made by the office? If you take away I just wonder if it's really true that the whole office is disqualified on that basis, because one attorney in the office brought represented the complainant and initially brought the action and obtained the CPO. You see what I'm wondering?
So when we say disinterested prosecutor, we mean a prosecutor without a conflict. And so if the fact that the Office of the Attorney General represented the petitioner, yes, it was a specific AAG, but it was the office itself that made the decision that that they should support this petitioner in their action for a CPO, that establishes a conflict that renders the office incapable of providing a disinterested prosecutor or a prosecutor without conflict.
Even when it's in a different proceeding related, to be sure, seeking contempt rather than just seeking to get the CPO.
I think the nature of the proceeding makes it particularly problematic. You have the court saying in Jackson that the person who represents or the person who acts as the prosecutor cannot be the person who represented the petitioner in the underlying, the order underlying the contempt prosecution. That's also the holding of Young. And right. So with how closely connected these two proceedings are, it's especially problematic to have a prior, or in this case, current client, being represented by the Office of the Attorney General in both matters. And so briefly, I just want to speak to the rest of the plain error prongs for our first issue, that this was a private action. The government hasn't made any arguments on prong 3 or 4. So we do think that they've essentially waived argument on that, but we would just like to emphasize that there is no authority in the US criminal justice system for a private prosecution. If this was a private prosecution, as Robertson said it had to be, then it absolutely meets the rest of the prongs. It is structural error, and it is a real embarrassment to the public reputation of the criminal justice system.
But what can you say again? And I'm sorry if I didn't quite pick up on it, but what is how do you argue that it's clear if the kind of one case that's really on point kind of cuts the other way, and you're left with the argument that during this particular window, that case that cuts the other way didn't really apply for these reasons that seem like something your opponent would completely disagree with? How do you get clarity?
So I think that the clarity on the fact that this was a private action is the fact that we presume everyone was following the law, and the law said it had to be a private action. So even though we now know, thanks to Robertson 2, that these cannot be brought as private actions, and thanks to the Supreme Court, that these cannot be brought as private actions, during that period of time, everyone was following this erroneous, unlawful holding of Robertson 1, that these are prosecutions apart from the general US prosecutions that are brought in the name of the sovereign.
And it just didn't apply to Robertson himself because Green didn't really establish it as clearly as Robertson 1 did.
Exactly. And because the Robertson 2 court sort of re-reflected on that, the case law that was, it dismissed in Robertson 1 and said, that case law is clear. Dixon, all of these historic Supreme Court cases, the statutory authority for prosecutions in the district, all of that says very conclusively that these have to be brought in the name of the sovereign. And so the Robertson court, the literal trial court would have understood that they were prosecuting Robertson in the name and interest of the United States. But when you have something that acknowledges all of those authorities and says, this is different, those do not apply to this kind of prosecution, then you have to assume everyone is going to comply with Robertson 1 and say that, okay, those authorities don't apply to Robertson 1. And these are private actions, even though that seems sort of antithetical to the criminal justice system that we have here. So I see my time is up.
Okay, well, let us hear from counsel for the United States, and then we'll give you a few minutes for rebuttal.
Thank you. May it please the court. Timothy Cahill for the United States. The trial court here did not plainly err by failing to appoint a different prosecutor sua sponte, where the procedures in this case in the court were identical to those in Robertson 2. And this court has never held those procedures to be erroneous. I'd like to begin by addressing where appellant's counsel left off, which is on the first claim regarding whether this case was, the underlying contempt trial was conducted pursuant to the power of the sovereign. In Robertson 2, this court corrected what it perceived and characterized as a misapprehension in Robertson 1, that the underlying proceedings in that case had been conducted pursuant to the power of a private party. At the time of Robertson 1, or excuse me, at the time of the contempt trial in Robertson, everyone was already operating under that misapprehension. And the misapprehension wasn't created by Robertson 1. The misapprehension was at that point confirmed by Robertson 1 until this court corrected it in Robertson 2. So in that respect, Your Honor, we would submit that this case was in the same posture. The case for Mr. Wolfe was in the same posture, where at the time that the trial was being conducted, the parties in the court were under the misapprehension that it was being conducted pursuant to the power of a private party. Robertson 2 corrected that misapprehension for both the Robertson case, and it would apply equally here.
So you think then Robertson 1 did not really take another step beyond what the existing law was?
Your Honor, even if it took an additional step, I don't think it would be a step that had any meaningful impact on the analysis here as to whether or not the parties what perception the parties were operating under. And I say that because Robertson 2 didn't actually focus at all on the perception that the parties were operating under. Critical to Robertson 2's holding is that the labels that the parties were operating under, the caption, what the person was identifying themselves at court, that actually wasn't determinative in determining the nature of the proceeding. What was determinative was, in the court framed it as the substance of the proceeding and the character of the relief. And for that, it identified the DC Code statutes and the criminal rules under which the proceedings played out. Those statutes and those criminal rules were the same in Robertson as they were here. So the nature of the substance of the proceeding and the character of the relief were the same in this case as they were in Robertson. So we submit that Robertson 2 is directly on point and is controlling and forecloses appellant's first claim here. But moving on to appellant's second claim, we submit that there was no error and certainly no clear or obvious error with respect to the OAG's role in prosecuting the contempt trial in this case. And I would begin by noting that that's because this trial doesn't implicate, or did not implicate, the types of concerns about interested prosecutors that animated this court's decisions in cases like Jackson and Taylor, or the Supreme Court's decision in Young. In all of those cases, there was no government prosecutor, no public prosecutor involved in any capacity. Those cases involved either a private individual operating pro se to bring criminal charges, as was the case in Taylor, or attorneys from private practice, as was the case in Young, who had been hired by a private entity in connection with civil litigation in which there were monetary stakes for both the private company and the private attorney. The situation we have here was very different. Ms. AAG Berry, who actually prosecuted the contempt trial, was an AAG from the OAG's office. She identified herself as such on the record, even though there was a misapprehension she was operating on behalf of the petitioner. There was no mystery about her identity as an assistant attorney general. She had no financial stake or other extrinsic interest in this case. And she was not actually, in fact, the same AAG who had been involved in the prior civil proceeding at which the CPO was secured.
But she was the colleague of that person, right? And what about her? Why doesn't she fall within the language of Jackson, a public attorney with conflicting and
Certainly, Your Honor. So I would note, first of all, that in Jackson, the vast majority of Jackson's discussion about interested prosecutors fall into the categories I just mentioned. Your Honor does correctly point out that there is a reference, and it's at the end of that discussion, to a public attorney who has conflicting interests. I would note that the Jackson decision, which came in the wake of Robertson 2, multiple times references Robertson 2 and what happened in Robertson 2 in the scope of that opinion. And every time Robertson 2 is mentioned and is discussed, it is to favorably distinguish the procedure that happened in Robertson 2 as being preferable and being a preferred mechanism for prosecuting these types of cases because there was an involvement of an assistant attorney general. So I don't believe at the very least that it would be clear or obvious from reading Jackson that the reference to a public attorney with conflicting interests would be meant to apply to the exact situation, the exact procedure that played out in Robertson 2, that same decision repeatedly cites as the preferred process, the process in which OAG was involved. And I would note that what seems much more likely and much more reasonable interpretation of that reference to a prosecutor with conflicting interests are the types of cases, a public attorney who has conflicting interests, are the types of cases, frankly, that appellant cites from other jurisdictions where courts have found that actual public prosecutors had conflicting interests. One would be the Ganger case from the Fourth Circuit, in which case a public prosecutor was actually prosecuting a crime in which he was simultaneously in private practice representing the victim of the case in a divorce proceeding, in which case he had a financial interest, much more akin to the cases where private attorneys from private practice had financial interests. Another case appellant relies on is the Spiker case from the 11th Circuit. In that case, the court found that the prosecutor ended up having a very personal interest in the case because the defendant had actually hired a hitman to have the prosecutor murdered during the course of the proceedings. And the court determined that under those very extreme facts, that the person had a very personal extrinsic interest in the outcome of the proceedings. But those are a far cry from a scenario in which an AAG, and in fact, a different AAG than the one who was actually involved in the CPO proceedings, is prosecuting the case and prosecuting it, from what we can tell from the record, in all manner consistent with what one would expect a public prosecutor to do. We see in the record.
Isn't it right that it's you can imagine a prosecutor with, who is just who didn't have this interest of having represented the client. I'm just setting aside for the moment that there are different prosecutors, like making the decision not to go forward with the prosecution, or not seeking jail time, which, I was looking at the sentences and thinking, well, he didn't really get jail time because he got suspended sentence, but then I was found persuasive the argument about who knows if, there wouldn't have been supervised probation, there would have been unsupervised probation or a lesser term. Why aren't all those things sort of naturally an unconflicted prosecutor might do?
So I'd say, Your Honor, first of all, based on the record we have in this case, I don't believe there's any basis to presume that those sorts of interests interfered or actually motivated AAG Berry's decisions in this case. The actions that we see her taking, such as dismissing a charge that was unsupported by the evidence, making a distinction at trial between whether attorney-client privilege applied to conversations with the AAG about civil proceedings or about the underlying criminal charge here, and actually not objecting on that basis when there were questions about the criminal charge, are consistent with her viewing her role as a government attorney. But even more fundamentally, to go to, I think, Your Honor's broader point, it is correct, as appellant has pointed out, that this is no longer the procedure that's operating in Superior Court. Superior Court now will not appoint an AAG in this context. And we would agree that that's the better practice. To say that it's the better practice is not to say that it's a constitutionally required practice. We don't believe that the prior practice was a violation of due process. But this sort of scenario, this sort of process that plays out, and that played out in this case and played out prior to Robertson 2, does raise some difficult questions, or at least has the potential to. We don't believe the record in this case reflects that it did, but it has the potential to. And so in an abundance of caution, Superior Court changing its procedures to avoid even the potential of those situations arising certainly would seem to be the best practice. But the question
I guess when you're talking about all the things the prosecutor did here that sort of look like this was, a very legitimate, kosher, whatever, prosecution. That's not sorry, I lost my train of thought, but it's not what you would expect. I'm sorry, go on and I'll gather my thoughts when you're continuing.
Certainly, Your Honor. So I was going to say that the question for this court isn't whether or not there is a better practice. The Superior Court's already made a determination that there is. They've already implemented the question.
I'm sorry, I remember
Yes.
now. Isn't it the case that the whole point is that we don't know? Like this is a sort of hard to know thing when you have a conflict like this. You just don't know how it affected things.
I think there is some truth to that, Your Honor, and even if the government in Taylor took a contrary position, this court has now decided that, for example, if a court has decided that there's a due process violation with an interested prosecutor, this court has decided that prejudice on the third prong is presumed. But I do believe that it's still relevant to look at the record specifically of what happened here. So first of all, to take one step back, we don't believe the court would even need to reach the fourth prong of plain error review. Of course, we don't believe that there is a clear or obvious error here. But if one were to reach the fourth prong of plain error review, I think all of the specific facts from the record that have been identifying here are extremely relevant. And I would point out that even in Taylor, in a case where the process followed was that the actual private party, pro se, was able to prosecute those criminal charges. When this court reached the fourth prong of plain error review, it expressly stopped short of indicating that that process alone was enough per se to satisfy that fourth prong. It actually said that, it expressly said that in another case where it wasn't so clear that this person acting pro se was motivated by a personal vendetta, where the case had devolved into an embarrassing mess, it's possible that fourth prong might not be satisfied, even in a case where someone was as interested as being the party themselves prosecuting the case. So we note that the fact that all indications in the record here that the court is taking the case-by-case analysis that's necessary on the fourth prong of plain error review, all of the indications that this trial, was conducted by someone with the professionalism and decorum of a public prosecutor who was making the sorts of decisions one would expect a public prosecutor to make, like dismissing charges when they aren't sustained by the evidence, when they aren't backed by the evidence, that far from undermining the court's authority, this was a case that vindicated it. And I mean, another distinction there from Taylor would be that in Taylor, the trial court on the record repeatedly indicated that the court was frustrated with this seeming abuse of the court's process. Here we had the opposite. At sentencing, this court indicated that this sentence, that this verdict in the sentence was necessary to vindicate the importance of the seriousness of the court's orders. And when the court issued the sentence in this case, it made a point of stating that it was important that the defendant understand that the CPO and any order issued by the court was a very serious matter. So, I mean, to the extent the trial judge weighed in here, it was on the side of vindicating, that this was a process that vindicated the court's authority, which is exactly the opposite of what happened, at least according to the trial court in Taylor.
I'd like to step back and ask you about a couple of things here that have come up in the discussion that you and Judge Beckwith have just been having. I'm under the impression, and I don't know that you really disagree with this, that if in fact the prosecutor is not disinterested, whatever that means, but if in fact the prosecutor is not disinterested, then that's sort of the end of the inquiry, in the following sense. We don't look to see, well, in the record, can we point to instances in which the prosecutors, we'll call it conflict of interest, or interest on the part of a private party, or however one wants to frame it. We don't look for things in the record to see, well, did that lack of disinterest actually result in harm to the defendant or cause prejudice in some way? We say, I think, that there's been a violation here because you can't really tell from a cold record the innumerable ways in which a lack of disinterestedness could affect the prosecution. So it seems to me the issue really does turn on whether we have a disinterested prosecutor or not. And on that question, as you said earlier, right, at the beginning of your discussion, the prosecutor in this case was under a misapprehension that she was acting on behalf of the complainant, of the petitioner. That to me, you know, if the prosecutor was under that misapprehension, then under the rules of ethics, the prosecutor has to be a zealous advocate, not for the public interest and not for the United States, but for the petitioner, for the complainant. And that in itself is the essence of lack of the disinterestedness that due process requires. And to the point, and satisfies the first three prongs essentially of plain error analysis. And on the fourth prong, while it is true, we do look at the facts and circumstances of the particular case. Where you have something like a non-disinterested prosecutor throughout the entire case, making every decision essentially on the part of the prosecution in the case, from whether to pursue it at all to what kind of sentence to put on, to ask, to what kind of evidence to present, all sorts of things, to what to ask the witnesses, what not to ask the witnesses, what to withhold, refrain from asking. That does seem to me to satisfy the fourth prong as well. I take your point that Robinson, that one of the hard questions in this case is whether, you could put it this way, whether our hands are tied by Robertson too, Robertson too. But if I can keep that straight. But on the disinterestedness point, Robertson too didn't really focus on that. They didn't think about that when they wrote Robertson too, and they didn't address the issue. And just as you can have a judge who is not a disinterested prosecutor, or a non-lawyer who's not a disinterested prosecutor, you could also have a prosecutor who's not a disinterested prosecutor. And so that all that leads me to think that, you know, there was not a disinterested prosecutor in this case, pure and simple, and all four prongs of plain error analysis are satisfied.
So, Your Honor, I'll take your, I think there were sort of two stages to the
There were
question.
there were
I'll
two aspects to that, and that's why I'd like you to.
So certainly, and I'll try to take them actually what I think is in reverse order, because I think it more aligns with the following the sequence of the prongs of plain error review. So with respect to the question of whether in this particular scenario, under this particular process, the prosecutor would be considered disinterested. I would agree that Robertson 2 does not expressly address that issue. Robertson 2 is addressing a different issue about pursuant to the power of the sovereign. But it's important then, especially on plain error review, where the standard is that there's a clear or obvious error under the cases of this court or the Supreme Court, to read both Jackson and Taylor in the context of Robertson 2, their familiarity with Robertson 2, and the references that those decisions make to Robertson 2. And so in Jackson, the case that appellant relies primarily on for this, the rule about having a disinterested prosecutor, again, all of the references to Robertson 2, a case in which the procedures followed were identical to the procedures followed here. Jackson makes reference to Robertson 2 only to favorably distinguish the procedures in that case as the preferable outcome, because the involvement of someone from the OAG's office, the involvement of a government prosecutor, was a preferable process, made that case more constitutionally sound than the scenario that played out in Jackson.
One question for you about this. Jackson did not, I think what you say about Jackson is correct, okay. But today, as we sit here, the issue is it clear that the prosecutor here was not disinterested, and that the absence of a disinterested prosecutor, because the prosecutor was laboring under the misapprehension that she was representing a private individual and not the United States. And if that is true, if it is clear now that that was an error, that was not a disinterested prosecutor, isn't that the end of the inquiry?
Well, Your Honor, but the question
Even
is,
if yesterday it wasn't clear.
Of course, Your Honor, but the question is, it would have to be clear now under the law as it exists now. And the law as it exists now, I mean, the cases in which this court has chimed in has examined this process, the CPO process, excuse me, the contempt process for violating a CPO. I mean, those cases are Robertson 2, are Jackson, and are Taylor. So reading those cases and what those cases, the scope of those cases does determine what is clear or obvious under the law now.
It's interesting because it seems to be clear in the Superior Court, because don't they now take the position officially that they will not appoint and for that matter, I think the Attorney General's office recognizes this, that they will not appoint the Attorney General to prosecute a contempt proceeding where the Attorney General represented the complainant in getting the CPO?
That is the process, Your Honor.
It seems if they've recognized it, why can't we?
Well, because Your Honor, as I stated earlier, the fact that they've recognized a better practice doesn't mean that the prior practice was constitutionally infirm. I mean, we would acknowledge that avoiding any potentiality of these types of issues, or even the appearance of these types of issues, may be preferable. But that's a far cry from indicating that the prior process, which the only time this court has ever ruled on.
In what sense is there a distinction here between the appearance of disinterestedness created by the fact that the prosecutor represented the complainant and the actuality of a lack of disinterest? I said that wrong. The appearance of non-disinterestedness. You know what I meant. And the actuality of non-disinterested. The appearance is the. I mean, if you're an attorney and you represent and believe you're representing the complainant, then it's not just the appearance of disinterestedness. Excuse me, I keep saying appearance. It's not just the appearance of a lack of disinterestedness. You are officially disinterested.
And so for that
officially not disinterested. I'll get it eventually.
Understood, Your Honor. And so with respect to that, I would point out, to hone back in on the actual record we have of what happened in this case, of how the AAG actually prosecuted this case. And for the reason I would want to delve into, and I think it's relevant to delve into the facts of what actually happened, are Robertson 2's broader statement about the fact that it's not the labels that control, it's the actual character of the proceedings that happen. I understand that that was in a slightly different context, but the principle is certainly sound and applicable here. And that the way that all indications we have on the record here is that the AAG was operating in the way that you would expect a government prosecutor to do. And I feel like one very clear example of this is that during the trial, when there were questions about the CPO petitioner's discussions with an attorney, someone from the OAG's office, an AAG. One of those questions was objected to on the grounds of attorney-client privilege, and one of them was not. And the one that was objected to on the grounds of attorney-client privilege was where those were questions about advice about the procedures for getting the TPO or the CPO, which was very clearly a civil process. But when there were questions about a conversation with someone from the AAG's office about the actual underlying crime, about the criminal offense, there was no objection on the grounds that that would be covered by attorney-client privilege, which I think is a pretty clear indication in the record that the AAG prosecuting the case, whatever formal caption was appointed to the case, whatever understanding there was of the formal structure of how this type of contempt case could have been prosecuted based on the pre-Robertson 2 misapprehensions, the AAG viewed her role as that of a government prosecutor, that she viewed her role and conducted herself accordingly. She didn't try to apply attorney-client privilege to leave out, statements made by, in this case, a witness or a victim viewing this as a criminal prosecution that were about the facts of the crime. That testimony was solicited and it was given. And similarly, the fact that the AAG actually dismissed charges that weren't supported. Again, the actual record we have here seems to indicate, all indications, that the AAG operated consistent with the role of a government prosecutor. But if I may, Your Honor, I also did want to, before got sort of lost in the shuffle, address what have been, I think, the first prong of your question earlier, which to my mind relates mostly to the fourth prong of plain error review, which is you asked that if this court finds, which we of course would disagree with, but if this court does have concerns or does find that there's a clear or obvious error here based on the presence of an interested prosecutor, if that is simply the end of the inquiry. And again, I would point to the way this court in Taylor, in a case where the court found that there was an interested prosecutor because the prosecutor was the actual party. I mean, it wasn't someone who, the question was whose loyalty was this person, it was the actual party themselves. This court actually very expressly stopped short of saying that that alone necessarily would be satisfy the fourth prong of plain error. So I feel like the fact that this court made an express point that the process followed in Taylor did not in and of itself satisfy the fourth prong of plain error certainly means that the process followed here can't per se satisfy the fourth prong of plain error. It requires an actual analysis, an actual look at what happened in this case, just as this court took a look at what happened in Taylor and said that in Taylor, it wasn't just the process that there was an interested prosecutor. It's that because of that, this played out into what the trial court called an embarrassing mess that actually did, to the court's mind, harm the public reputation of the judicial proceedings where the powers of the court were being used to play out this personal vendetta. Everything in the record here is an extremely far cry from what happened in Taylor. We had someone from the AAG's office prosecuting the case with the professionalism, decorum of a public prosecutor, making decisions like dismissing charges, making distinctions between the civil proceeding that occurred before and the criminal process that happened here. And then you had, again, in a direct contrast to Taylor, the trial judge on the record indicating, making clear that the trial judge viewed the process here as having vindicated the powers of the court, not having undermined them as the court did in Taylor.
Is it accurate to say, though, that you agree, I understand you disagree that the prongs are met, but if the first two prongs are met, you agree it's structural error?
So the government took a different position on that in Taylor, but now that this court has issued Taylor, I think that the fair reading of Taylor is that this court has settled that issue in this jurisdiction, that it is a structural error if it rises to the level of a due process disinterested prosecutor.
But you just think this would be the rare case where structural error doesn't lead to a prong 4 finding, basically because Taylor said something in completely different circumstances.
No, Your Honor, I would say, first to the first question, yes. If the court, again, we don't think the court needs to reach that prong, but if the court does, we do believe that this would be the rare case that would meet it. To the extent that it would be a rare case, I think it's undeniable that the actual process that unfolded here and the process that existed prior to Robertson II is a somewhat unusual legal context for a court to be examining. And it would warrant something that, a decision outside the norm, given that this was a somewhat unusual legal process, unusual legal procedure. And my point, Your Honor, with respect to Taylor is that, circling back to Judge Glickman's question, which is that if the court found there to be an interested prosecutor, is at the end of the story. And Taylor just made clear that it wasn't. I understand Taylor was a different context. In fact, that was part of the point. Taylor was a very different context. But in Taylor, the court didn't just say, we found an interested prosecutor, we're done. In fact, it expressly said the opposite. It said that we were limiting this case. This case is limited and driven by the very specific facts of what happened at this trial. That the court uses that limiting language in the decision to make clear that its decision on prong 4 is based on a case-specific analysis. And so, Your Honor, my point is that not just because Taylor said that, therefore automatically his case somehow gets through, because Taylor ultimately reached the opposite conclusion, right, on very different facts. But I was trying to distinguish the facts of Taylor from the facts of this case, which are very, very different. And based on the facts of this case and the unusual process that led there, we do believe that if this court were to reach prong 4, this would be the rare case that would justify affirming based, prong 4 and the court exercising its discretion not to reverse.
Correct me if I misremember. Wasn't one of the things that happened at trial in this case that the prosecutor affirmatively requested jail time for Mr. Wolfe?
I believe that the prosecutor requested a sentence of 5 days, and the court issued a sentence which was not far off on that numerically. I understand, obviously, there's a big distinction between any jail time and no jail time. The court issued a sentence of 180 days suspended as all.
Given the underlying conduct involved, which was simply the brief contact that was described in the proceeding at when the two people met at a bar by happenstance, apparently. It struck me that a little surprising that the prosecutor was asking for jail time.
I think it's relevant in that context, Your Honor, and so to look at, for instance, the victim impact statement in this case, which of course preceded the allocution, and lest I be misinterpreted here, I'm not saying that the victim gets to decide the sentence, but of course, in a criminal proceeding in which there's no doubt about the fact that there's a disinterested prosecutor, there are victim rights statutes that require a prosecutor to take into account, not to follow blindly, but to take into account the interests of the victim and the impact that the case had on the victim. And although, superficially the interaction here may have seemed benign, the victim impact statement in this case, made very clear that the victim was terrified during this entire encounter, that so soon after having been given an express court order not to have any interaction with her, Mr. Wolfe not only interacted with her, but did so very brazenly, sat down, made physical contact with her and with her companion. And so even to someone watching that from afar might not think that it was a particularly threatening encounter. It was clear in the context of this case that it was. Be that as it may, Your Honor, I'm not going to, I don't think it's necessary to the court to evaluate exactly what the sentence could or should have been in this case. But I think in the context of this case, that is not an indication in the record that anything untoward happened or that the prosecutor was being unduly influenced by the victim's wishes, but was simply taking into account the victim's interest in a way that any
I don't mean that
candidate
as
should do.
I don't mean my comment as a question of, casting any aspersion on the prosecutor, but it does, it did lead me to wonder whether it had a bearing on whether we think the disinterestedness was there or not.
Understood, Your Honor. I would simply say that certainly in the context of the entire record, we would submit that the overwhelming evidence in the record is all indications that we have in the record that more clear, to our mind, more directly bear on this point.
Here's another way in which, do I remember this correctly? The former prosecutor was on the witness stand. Is that right?
That's correct, Your Honor.
And so you have a situation where the supposedly disinterested prosecutor is going to be examining on the witness stand their fellow prosecutor in the same office. That puts a little strain on the disinterestedness, doesn't it?
Don't believe so, Your Honor. The context I think here is significant, which is that the former prosecutor was testifying in a very narrow capacity about the facts leading to the service of the subpoena and provided sort of some background information about how the specific temporary protection order, how the specific service packet was prepared in this case. And certainly while it is unusual in a criminal proceeding for a prosecutor to be a witness, it would not be entirely unheard of if that prosecutor suddenly had information that was factually relevant to presenting the case for that person to withdraw.
A different sort of challenge to the disinterestedness from the one we're talking about. So
it would, Your Honor, and for that reason, I don't believe that it would directly bear on the claim that's at issue in this case. I do see that I am out of time, however, and so.
I have one more question for you. So that original prosecutor had to testify to those facts, and that's why it was represented. They did not continue the case themselves, and instead Barry came on. If the original one had continued the case, how would that change your analysis?
So, Your Honor, I don't believe that would necessarily instill the government's position rise to the level of a due process violation, but I would acknowledge that I believe one of the factors that weighs the other direction pretty heavily in this case is that it's a different prosecutor, and of course that factor would be absent if that was the scenario that had played out. Thank you. For all these reasons, we ask that the court affirm the judgment of the Superior Court.
thank you. Ms. Williams.
Thank you, Your Honor. So briefly, I think at some point during my opponent's discussion, Judge Glickman, you laid out exactly our position, and we would just like to endorse everything you said. This is a situation where the Attorney General was ethically required to zealously advocate for their client at the same time as they were ethically required to represent only the sovereign. And that is a textbook conflict. It means that the Assistant Attorney General was incapable of being a disinterested prosecutor in this case. And I'd also just like to correct some important factual points. So Assistant Attorney General Connell is the original prosecutor, as Judge Howard, I think, described her. She was the prosecutor for this case. She appeared at the arraignment. The trial court directed Mr. Wolfe to talk to her about a deal. She was the one who corrected, or I guess filed all of Ms. Korbach's motions to adjudicate contempt. And then I think a day before trial, there was a preliminary hearing where she said, I just realized I'm going to have to appear as a witness. So we're just going to have Barry do the prosecution that I have already prepared. This was Ms. Connell's case. It was not a situation where Barry was the primary prosecutor of this case or could ever be construed as the lead attorney. And so I think that to the extent that that is significant to the court or significant to the government, that's just not the nature of how this prosecution went down. And then I'd also like to address this notion that Connell was looking objectively at all of the charges and removing things that didn't have any sort of meat on the bone. That there's nothing in the record to suggest that. We know that the original charges were for a violation of a TPO that happened the day after the CPO was issued. The original motion to adjudicate contempt said that it was this interaction that happened in the hours after the TPO was served to Mr. Wolfe. And then it was an email to Ms. Korbach's mother and then a phone call to Ms. Korbach. And the email to Ms. Korbach's mother was what was removed. And then in the amended motion to adjudicate contempt. And then at trial, the Assistant Attorney General said that they were removing this phone call that potentially happened. There are many reasons why they might have wanted to remove those kinds of charges. It could have been that they would have reflected badly on Ms. Korbach in some manner. It could have been that they would have gotten to what was, in fact, Mr. Wolfe maintains what he believes to be part of the basis for this contempt prosecution, which was a civil suit for money that was in dispute during their relationship that he had brought in the days right before the CPO was issued. So there was a lot going on behind the scenes in this case that had absolutely nothing to do with whether or not these charges were something that the United States in its completely objective position would want to bring. So I just wanted to clarify the factual universe of this case. This isn't the sterling example of prosecutorial objectivism. This is an example of a attorney that was potentially very much taking the interests, and we argue definitely taking the interests of their client into account in their prosecutorial decision making. And I'd also just like to say, I would like to refer the court to the Taylor court's characterization of the argument that the government is making in response to our first issue, which essentially is this, that they argue Robertson II authorized a post hoc fiction wherein everyone in the courtroom could have believed they were engaging in a private action, but we should retroactively view that as a public action because otherwise it couldn't have lawfully happened, and that's the only way to save the prosecutions. And that is circular logic that the Taylor court didn't have to touch, but I implore this court to reject that argument. It is not grounded in the law. It's not grounded in Robertson II's holding, and it is very much ignoring what the holding of Robertson I was. And I'd also just like to speak a little bit to the difference between the prosecution of Mr. Wolfe and the prosecution of Mr. Robertson. There were a lot of different things, hallmarks of a governmental prosecution that were not present in Wolfe that were present in Mr. Robertson's prosecution, such as there was a Brady demand made and a Brady disclosure made in Mr. Robertson's case. There was nothing like that in Mr. Wolfe. We don't have anything in the record to suggest there was any sort of Brady, nothing to suggest Rule 16 compliance, nothing to suggest that these things that are for the protection of the defendant happened in Mr. Wolfe's case, whereas there is all of that in Robertson's case. And the reason for that is because the state of the law when Robertson was prosecuted was this, generations long law that said, this is a United States prosecution. And it doesn't matter that Miss Watson was the one who asked the Attorney General's office to bring this prosecution. It was still brought in the name and interest of the United States because that was the state of the law. And that was just not what the law said when Mr. Wolfe was prosecuted. And finally, everything that the Taylor court judge said about what was happening in the courtroom during Taylor, everything that he said about how he was powerless, how this was completely in the, the reins were held by the petitioner. They were the directors of this prosecution. That is the same judge who prosecuted or who oversaw Mr. Wolfe's prosecution. So everything that that judge thought about what the nature of that action was in Taylor is true in Wolfe. We just happen to have an assistant attorney general there. You have two lawyers at the table. It's not going to look as crazy as if you have two pro se people. There's not going to be as much hecticness happening when you're having this sort of feuding thing, but it doesn't change the fact that the nature of the action was a private action in both of those cases.
Could I ask you to briefly address the government's argument that Taylor, counsel's caution about saying that, I'll put it that way, counsel's caution about saying that the fourth prong has plain error has been satisfied here, that even in an egregious and as egregious a case as Taylor, the court, thought it was a close question, perhaps, whether the fourth prong was satisfied. And Taylor suggests that, therefore, the fourth prong may not be satisfied here.
So the Taylor court didn't say that this was a close question. The Taylor court said absolutely nothing about future cases that might present different factual scenarios. They emphasized what is true, that every prong for analysis is case specific, and the court has to look at the facts of the case. But what they emphasized in their discussion of Taylor was, I think you sort of implied this, Judge Glickman, was in part the fact that the disinterested prosecutor was completely supplanted. So you don't have a situation where you have a disinterested prosecutor coming in for a short term and then they're replaced by a neutral prosecuting authority. You have a complete prosecution done in the hands of a conflicted prosecutor, and so for that point, that is one of the major things. That's the difference between Barrows and the vast majority of these structural error cases. Barrows was a very small, limited, cabined error because it happened just for a very brief period of time that they closed the court during voir dire. And the court found that in that sort of scenario where you have a temporary closure of the court and they wouldn't have been able to hear anything anyway because the husher was running, all of that made that not quite a prong 4 error. But here you have your sort of quintessential structural error where it pervades the entirety of the prosecution, and that Barrow reasoning just does not apply here. And then on top of that, you also have a lot of discussion in Taylor about the importance of the screening function of prosecutors. There's limited resources. There's a lengthy footnote that's dropped in response to DV Leap and their amicus brief, where they essentially said, you have to let petitioners bring these cases or they won't be brought. And the court says, we rely on prosecutors to screen. We rely on neutral prosecutors not to bring every single case to the court. And if we allowed petitioners to do this, it would lead to a sort of over prosecution of these kinds of cases. And that same sort of absence of a neutral prosecutor to screen this case happened in Wolfe. That is potentially why this prosecution was brought. And it is noteworthy that this was a violation of the temporary protective order that was brought the day after the civil protection order went into effect. So this is a very rapid prosecutorial decision, and it is the conduct underlying the prosecution is not necessarily the kind of conduct that would always lead a neutral prosecutor to think this is worth the resources of the court. And so those two elements of Taylor that, Taylor spent a lot of time on those two pieces, those all apply here. And then finally, briefly, you have the fact that when you have an interested prosecutor wielding the authority of the criminal justice system, that is always going to impact the public reputation, the integrity, and the fairness of the proceeding. The prong 4 analysis is not a prejudice to the defendant analysis, it's a prejudice to the court analysis. And there are a few things that are as prejudicial to the court as a biased person standing in for the government and potentially wielding their authority in a way that is to comply with the whims of a private actor. So for those reasons, Your Honor, we ask the court to reverse.
Council, thank you both. Case is now submitted. And the court will stand adjourned.